Welcome all. I am Dr. B.S. Patil and I am making a presentation on module 12, Access to Justice and Children. The content writer of this module is Mrunmayi M. Vaidya and I am making a presentation on her behalf. We both are connected with V.M. Salgaonkar College of Law, Goa. In today's presentation, that is regarding access to justice and children, the scheme that I have prepared for the presentation would be a brief introduction about the children rights, plus the legislations which are protecting the rights of the children, procedural protection for the children. In case a child is suffering or is a victim of any crime, in such case how the grievance redressal mechanism has been built in, and then finally I will be taking up a judicial view on these legislations. However, when I take up a discussion on access to justice and the children, the meaning of access to justice has to undergo a certain structural changes. Here, traditionally access to justice means access to the court. A person aggrieved should have an access to the court. That is what the access to justice means in a traditional sense. But when we take up the discussion on access to justice to the children, it takes a different view. So, therefore, here we are going to study access to justice in a modern view, wherein we are trying to look into the law which protect the rights of the children. How protection of rights of children becomes access to justice. The reason being, the children being a vulnerable group, children being a group which are subjected or which are potential to be subjected to exploitation, they need a certain kind of additional protection. Plus, the fragile mind of the child and immature minds of the child leads to certain kind of wrong decision which may tend to put them into difficult situation. So, therefore, there is a need to look into the meaning of access to justice in a new sense. So, therefore, access to justice here means special nurturing, special provisions to provide for all round growth, healthy environment for the child, as well as overall well being of the child. How these things are assured by our present legal system. So, that is what we are going to look into in today's discussion. Do the children are vulnerable? What kind of child can be subjected to vulnerability? Are there any specific kind of children who are particularly very safe compared to the other children? The answer for these multiple questions which frequently comes to the minds of the people is that all children are vulnerable for exploitation. Child labor, it is a kind of an exploitation which a specific kind of child could be exposed, that is economically weak, belonging to a family of economically weaker section. But whereas when it comes to sexual abuse, trafficking and other kinds of child abuse, any child could be subjected to such kind of treatment. And mostly the situation would become much more difficult when the child is subjected to legal proceedings due to such a difficult situation. So, therefore, any kind of child could be subjected to vulnerable situation. Then the question arises, who is a child? So, when it comes to qualification to be a child, the age determining factor has been different for different purposes. So, based on the purpose, a different age has been fixed. So, if you take the example of marriage, under the Hindu law, the marriageable age or the adult age starts for boys from 18 years and for the girls it is 21 years. When it take up Guardian and Wards Act, the age of majority is decided based upon whether the person is under the custody of a natural guardian or under the guardian of appointed by the court. So, the age would be accordingly would be 18 and 21. When it comes to right to education, the age differs, that is the 6 to 14 is considered as child. When it comes to mining, under the Mines Act, a child cannot be employed in minings or mining activity. So, only a child who is above or only the person who is above the age of 18 could be employed under mining activity. So, therefore, age here would be 18. When it comes to Child Labour Regulation and Prohibition Act, the age fixed is 14. So, any child below 14 years of age cannot be employed in any kind of hazardous industries. So, therefore, the age factor differs based upon the purpose. So, when we look into legislations, we are going to look into 4 important aspects of these legislations. Number 1, whether these legislations are providing for social justice, non-discrimination, and very importantly equality and empowerment. So, taking these into considerations, I am going to put up certain of provisions for discussion. First, I will take up Constitution and the child. So, part 3 and part 4 of the Constitution of India provides certain provisions where child rights have been protected. Under part 3, the article 15 speaks about no discrimination among the citizens, but whereas there is a protective discrimination where any law in favor of women and child could be made. So, that is article 15 where the legislatures or we can say the government has the power to make a law favoring the children. Article 21A provides free education, that is compulsory and free education between 6 to 14. Article 39A, which falls under part 4 of the Constitution of India, provides for provisions where health and the strength of the child should be protected and encouraged. And then 39A itself again provides for a situation where a child should not be allowed to take up a job which is unsuitable for its strength and the age. So, that is a provision where a clear cut mandate is given to the state that to make a provisions where such employment is avoided or prohibited. Finally, article 39F, which provides for opportunities and facilities to be provided to develop, grow in a healthy manner, conditions of freedom and dignity, and even a protection against exploitation. So, all of these provisions have been made, the mandate have been made by the Indian Constitution. So, moving from Constitution to the procedural protection for children. Traditionally, we have 3 legislations which deal with criminal laws in India, that is Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. So, we are going to look into these legislations specifically from the point of view of child. So, let me take up first Indian Penal Code. Under this Indian Penal Code, there are 2 age is been fixed. One is below 7 years and another is between 7 to 12. So, when you take up a child below 7 years of age, there is a presumption in the law where it says that a child below 7 years is incapable of holding mens rea, that is guilty mind. Therefore, below 7 years of age, there cannot be a guilty mind and there cannot be a punishment. Similarly, between 7 to 12, whether similar provision is been made, there is a slight distinction between the earlier children of earlier age duration. Now, here between 7 to 12, the presumption is applicable only if the child, depending upon the maturity level of the child. So, therefore, when it comes to 7 to 12, the presumption or the exemption is still applicable but at the discretion of the court. If the court feels the child is still is not matured enough or still it is immature, then the exemption could be extended, that is the exemption of a doli in capax could be extended to the other party. So, this is how IPC has given certain level of protection to the child. CRPC, that is Criminal Procedure Code. Now, here when we take up the discussion on Criminal Procedure Code, during investigation police has a power to secure the attendance of the witnesses, and this is for the purpose of investigation. However, the police power to secure the attendance has been substantially restricted when it comes to the witnesses, if they are, when it comes to women witness and the child witness. So, here they are providing an exemption where a police cannot summon women or children to the police station. If at all there needs to be interrogated, questioned, then the police has to go to the place where the women or the child is residing. So, therefore, with this provision, all women, whether it is a girl child or a grown up, are protected against the visiting of the police station, and a child, male or female, below the 15 years of age cannot be called to the police station. The object behind this is the law feels that the person, the child, should not be exposed to the intimidating atmosphere and the conditions at the police station. Further, in CRPC itself, there is a provision for examination of victims. So, when it comes to examination of a female victim, it has to be conducted by a female medical examiner, a registered practitioner. So, therefore, there is a protection of a dignity to a girl child, but it is extended to all women, but we can also consider it as a girl child is protected under this provision. At the same time, let us take up the last provision, that is about the locus standi. Now, locus standi is who can move the investigation proceedings under the criminal law. It is the victim only. A victim who has suffered a crime should go approach the police station and initiate the proceedings. If not, the other people, the general public, are prohibited from initiating the criminal proceedings. The exception is created if the victim happens to be below 18 years of age. So, in such situation, any person, the person who is having information about the violation can initiate criminal proceedings. It is possible only if the victim is below 18 years of age. Then law of evidence. So, law of evidence, in this the special provision for the child is taken only in case of witness. So, witness is a very important part of a litigation process, and witness generally is subjected to a kind of intimidating questions and other things. So, whether a child could be a competent witness. So, in this case the law says a child with a tender age, please note that there is no age fixed under law of evidence. A child of a tender age, if it finds or if he is not in a position to understand the questions, understand what answer to be given, then such child cannot be taken as the witness. So, therefore, there is a kind of a protection granted to the child at the cost of justice. So, here why child interest is protected rather than the justice. Now, here again there is a choice made by the law. If child is allowed, there can be miscarriage of justice. If child is not allowed, again there are chance of miscarriage of justice. So, either way the chances do exist. So, therefore, they prefer to protect the interest of the child, and the burden is put on the prosecution to find out the other way, tedious way to come to justice. Legal Service Authorities Act also provides a provision for protecting the interest of the child in the form of providing legal assistance. So, the Legal Service Authorities Act gives a list who are entitled for the assistance. In the list there is child or children name is present. So, they can access the legal services. So, these are about the general provisions where child rights have been protected, access to justice for the children is being encouraged. Let us move on to the little serious note on grievance redressal mechanisms. So, when a child is being a victim or being accused of a crime, under such circumstances how the law take into consideration. So, under this discussion, the first law which I am going to take up for the discussion is Commission for Protection of Child Act 2005. Now, this act is being established in the line of Human Rights Commission Act. So, like Human Rights Commission, here two commissions are established under this legislation, that is the Commission, National Commission for Child Rights and the State Commission for Child Rights. These commissions are non-adjudicatory authorities, they are only recommendatory bodies, and they have power to conduct investigation and inquiry into the provisions, into the incidents, and after conducting inquiry and investigation they can give the recommendations. In case any specific cases come before these commissions on behalf of the victim can move the court. They can go to Supreme Court or the High Court and seek for a proper directions in the form of writ. The commissions enjoy the power of civil court for the purpose of conducting investigation and inquiry, which generally include the power to issue summons, power to examine witnesses, power to examine the documents connected with the dispute, as well as power to enter the premises for the purpose of investigation. In addition to these powers, there are responsibilities that has been attached with these commissions, which include responsibility to protect the child in distress, child of marginalized and disadvantaged group. So, the child in distress could be a victim of a crime or may be accused of a crime. Marginalized and disadvantaged group could be a child belonging to economically backward section, socially backward section. So, these children needs to be taken care of. Children in conflict with law, that is the accused child. The children without family, so who is in need of care and protection. So, the commission is under the responsibility to provide support for such kind of children. And finally, even they have to extend the help to the children of prisoners. So, the responsibility also include that wherever these children in need of help are been put up, they can periodically conduct inspection and find out the status of the children. In addition to the commissions, the Act also provides for establishment of children's court. In this children's court, the Act provides that any district court could be designated as a children's court, and in this children's court any offences committed by the child could be tried, or any victim of a crime could be tried. So, a sessions court could be recognized as a children court, and each children court will have special public prosecutor to represent the children. Moving on to the next act, that is Protection of Children from Sexual Offences Act 2012. There is two things that we should keep in mind, that it is applicable only to the girl child, and that too a girl child who has suffered or who has undergone sexual abuse. And this is another fact that is to be kept in mind, is this is the only legislation which is been enacted keeping the victim child in the mind, or else all these days or all these legislations take accused child in mind, and there are protection granted to the accused child. So, wherever, so the child, the girl child is prone, or even a male child is prone for sexual abuses due to lack of knowledge of sexual advances. Secondly, the offender prefers the child could be intimidated easily from keeping the incident secret. So, therefore, the child, generally girl or boy, are subjected to sexual exploitations. So, the act provides for reporting and investigation process where any person who has the knowledge of such incident could report to the investigation officers. So, there is no need for the child herself or the parents of the child should initiate the criminal proceedings. The additional provisions which are there for protecting the interest of the child is that the recording of evidence should be done in the language of the child, which the child is having the knowledge of it. The statement should be recorded at the residence of the child, not at the place where the police wants or at a place where the child feels comfortable. During recording of the statement, the police are not allowed to wear their uniform. So, they have to be there in a plain clothes. And in addition to these things, there are few additional provisions which go in a long way in protecting the interest of the child. That is, every witness, that is when the child is interviewed, the interview should be audio and video recorded, so that child need not go through the trouble of recollecting the incident again and again. So, the audio video recording would help the investigators to continue with the investigation. The identity of the child has to be protected, it cannot be revealed at any cost. The parent or the guardian must be present when the child is interviewed or when the child is medically examined. The girl child should be examined by the lady medical practitioners only. So, from this sexual offences act, we move on to child victim of a domestic violence. So, Domestic Violence Act 2005 provided for the protection for women and a girl child against the domestic violence. Home is a most safe place on earth for a child, but if the same home turns out to be a hell, a source of agony, a source of torture, then the child would be suffering mental torture in addition to the physical sufferings. So, therefore, such child needs additional protection. So, here in this Domestic Violence Act, as the act being a civil legislation, here there are no criminal remedies provided. So, there is no punishment as a part of the remedy, but there are various other remedies that they are provided under this. The remedy seekers or the beneficiaries under the act can be a woman or a girl child, as the scope is limited only to the female of a household. So, the reliefs could vary from protection orders, where the order could be passed by the court to protect or to not to interfere with the life of women or the child. The offender or the aggressor could be instructed strictly not to interfere with them, stay away from them, not to enter a specific premises for a specific time. Such protection orders could be passed. Residence order: if a girl child or the mother women is asked to leave home, they have got a right of residence in the same house, they can continue to stay. Monetary reliefs could also be asked for continuation for sustenance. Custody orders: in case the women or the mother and father are separated, and the custody could be granted under the Domestic Violence Act 2005. Compensation order could also be added into this process. So, from these legislations which specifically deals with one or other kind of offences or one or other kind of victims, we move on to the more general provision, that is Juvenile Justice Care and Protection of Children Act 2000. So, popularly it is known as JJ Act, Juvenile Justice Act. So, this Juvenile Justice Act has considered two kinds of children for the purpose of protection. One, the child in conflict with the law. wherein a child is an offender or accused of an offence. The other is a child in need of care and protection, where the child could be a victim or a child could be in distress, a child could be a part of marginalized section, or it could be anybody who is in need of care and protection. However, there is one category of child who has been excluded from the JJ Act is child as a victim during the proceedings. So, child as a victim is taken into consideration outside the proceedings, not during the proceedings. The outline of a JJ Act is the JJ Act take three things into consideration, three stages into consideration: stage of investigation, trial, and the final, the detention, if the child found to have committed the crime. And all these three stages, there are different set of authorities that have been created. At the investigation stage, the case is not conducted or held by a regular police station, but it is conducted and held by special juvenile police unit. Every police station will have this separate unit who is made in charge of holding investigation where child accused is involved. This unit is run by a personnel by name Juvenile Welfare Officer, who is also known as the Child Welfare Officer. So, this Child Welfare Officer conducts the investigation and comes up with the report to the Juvenile Justice Board. From investigation coming to the trial, generally the trial of the child is held not before any ordinary court, but it is brought before the JJ Board, Juvenile Justice Board. If the JJ Board finds the complaint is frivolous, trivial, then it can be referred to Juvenile Welfare Board, where there are Child Welfare Board which takes care of the children in need of protection and need of help. After trial, there is next stage, that is detention stage. So, if a child is found to have committed any kind of a crime, then the child initially is kept in an observation home, and then finally the child is transferred to special home. The difference between the observation and special home is like the difference between the police lockup and the jail. During the trial, the under trial are kept in a police lockup. During the investigation, the person is kept in a police lockup. Once he is convicted, he is sent to prison. Similarly, the observation home is the stage where the case is pending. After the decision, the child is transferred to special home. During all this process, we need to remember one more very important officer, that is probation officer. He is not the officer appointed under this act, but under the Probation of Offenders Act, but this officer plays a very important role that we will discuss during the other slides. So, when the investigation goes on, during the investigation and the trial, the JJ Board and the Child Welfare Officer needs to keep certain principles in mind, which is been passed by the central government in the year 2007. So, when the special juvenile police unit comes to know about the offence, the direction is given to the Child Welfare Officer to take up the investigation, and from there the matter is brought before the Juvenile Justice Board. The fundamental principles to kept in mind, some of them are overlapping with the fundamental criminal principles of criminal jurisprudence. So, therefore, I will just go through them and will make a brief discussion on them. Presumption of innocence, fundamental principle of a criminal jurisprudence. It has been adopted in JJ proceedings also. Dignity and worth. So, the child should be treated with dignity and worthy. Right to be heard, which is part of criminal proceedings. Best interest of the child. So, when the case is heard, the best interest of the child should be the paramount consideration other than other things. Next interesting principle is principle of family responsibility. The legislatures feel the best place in the world where the child could be brought up in a healthy environment is the family only and family itself. So, therefore, all sincere attempts should be made to take the child back to the family. Only when all the attempts fail, then the alternative method should be adopted. So, alternative methods are considered at the later stage, not in the beginning itself. Principle of safety, again the child needs to be protected against exploitations. Very important, the next principle is principle of non-stigmatization decisions and actions. So, the language used in the proceedings should not create stigma in the minds of the child. And then finally, right to privacy. So, coming back to the same authority which I had mentioned earlier, probation officer. This probation officer works along with child welfare officer, but the nature of the work is entirely different. Child welfare officer looks into the material fact of the incident. Say for example, child is being caught while committing theft. Child welfare officer conducts investigation on all the material facts which proves or disproves the theft. But the probation officer conducts an investigation in all connected matters. Other than the theft, all connected matters are taken into considerations, like what made him to commit theft, or what made him to fall into the trap, what made him to bring him into this situation which led to the criminal proceedings, what kind of family background the child is having, what kind of interest the child possesses. So, these are very important information which the probation officer collects, which in turn help the JJ board to come up with its award or its judgment, wherein a proper remedy could be awarded. In addition to this, providing of social investigation report, the probation officer also takes supervisory role. If a child is left on a bail, the supervision of the child, the behavioral pattern of the child is taken care of by the probation officer. When a final order is passed, the child is maybe left out on admonition or probation, the probation officer would conduct supervision over it. Post release, after release of the child, the social reintegration of the child is taken care of by the probation officer. Coming to the functions and the powers of Juvenile Justice Board. The procedure in JJ board has to be child friendly, it has to be very informal, the setup should be informal, it should be nothing like the court system, and the court premises should possess some a look which a child must feel comfortable. The ambience should be child friendly, and even the witness box should not be kept in the vicinity of the proceedings. While conducting the proceedings, the first rule which JJ board must possess is complete opportunity of hearing of the child. The child should be heard first. The duration which the JJ board has to come out with its decision is 4 months duration, and wherever not necessary, the child offender or the juvenile should not be asked to attend the court proceedings, so that the child is kept away from the intimidating proceedings that are held in the court. Further, the judges and the lawyers involved in the JJ board proceedings are prohibited from using some accusatory words, the jargons which become part of a practice, like arrest, accused, imprisonment, remand, charge sheet, prosecution. So, these words should be avoided from the proceedings. So, when it comes to final orders, JJ board can pronounce a series of final orders. First, it can pass an order of transferring the child to the Child Welfare Committee or Child Welfare Board. So, this happens if the court finds that the decision is frivolous or the proceedings itself is frivolous and trivial. So, the Child Welfare Board is asked to take care of the child's reintegration into the society. Release on probation. Even if the child is found guilty, the court may release him on probation with certain conditions. Release on admonition, where the JJ board finds him guilty, but they give a stern warning and ask the child to go free. In both the cases, the probation officer would follow the child, will supervise the child's reintegration into the society. Transfer to the special home. Now, this is a situation where the child is found guilty and the JJ board decides that he should be kept in confinement. So, he would be transferred to the special home. Group counseling, if the JJ board finds that he needs a certain kind of counseling which can reform the child. Fine to the parent, this is the interesting provision where if the child is arrested while at work, means the child is put into work. So, therefore, the beneficiaries of the child work that is the parents, they are fined for putting a child to work instead of the school. So, therefore, the juvenile in conflict with law could be sent to observation home or to the special home. Observation home is during the proceedings and the special home is after the proceedings. So, from JJ board, let us take up child in need of care and protection. So, when we talk about child in need of care and protection, so the child welfare committee take care of the child in need of care and protection. So, here the care and protection include shelter, safety and rehabilitation. The child in need of care. So, this information can be brought to the notice of the child welfare board by any of the following persons, from police, public servant to any public spirited citizen. So, when these persons bring it to the notice of the child welfare board, the board has a power to take the child out of the possession of the natural parents and keep it with any other home till the matter is sorted out. The decisions of the child welfare committee would vary from sending the child to the shelter home to sending the child to child care center, where the child is put under complete care, or child could also even given in adoption or foster care, or even it could be they could find sponsors for the child education and development. The decisions of the Juvenile Justice Board or Child Welfare Committee could go in appeal. So, there is a provision for appeal where the appeal lies with the Sessions Court, and further it could be brought before the High Court or the Supreme Court. So, this is about the child protection care under Juvenile Justice Act. The one last point which I want to mention, which I already told, that JJ Act do not protect the victims, child victims, it only deals with the child offenders. So, therefore, there is a need for new legislation on child victims. So, what we have done, the discussion in this access to justice of the children is the discussion on general laws, that is IPC, CRPC and Indian Evidence Act. Then we moved on to the specific laws, that is National Commission on Child Rights. Then we moved on to Juvenile Justice Act. Thank you.